Dear students, this is M. Koteswara Rao, LL.M. Commercial Law School, Nagpur University. I'm working in the Faculty of Law in the PS Raju Law College, which is affiliated to Adhikavi Nannaya University, Rajamahendravaram, East Godavari district. My dear friends, I am directed by the principal to take up the subject company law for the students, so as to enable the students to have the better understanding and also an acquaintance with the company law subject. As you know, friends, we had in our company law curriculum, we had the 4 units. Unit 1, Unit 2, Unit 3, Unit 4. So, for all these 4 units, the reference books that are available in our PS or Law College are: one is the Characterstics, the book from the Eastern Law Book House, and second one is Ramaya Company Law, and the other remaining reference books are the Company Law book written by Professor Gover, who is authoritative of the Company Law, and another one is the Palmer. He is also an authoritarian as far as our company law is concerned. So these are all the references books that are available. But as far as our law college is concerned, we had the reference book Ramaya that is readily available, and that book that I am following for these units especially. Secondly, my dear students, I want to convey to the students, I am not supporting that student edition books. There is one student edition book of Characterstics also is there, but I am not suggesting. As far as the reference book is concerned, the Characterstics that I suggest to the students. Besides that, my dear students, there are 2 books that are available in the markets and bookshops. That is, one is Company Law written by Andy Kapoor, and the second one is the Company Law book written by Maheshwari and Maheshwari. They are also up to the mark as far as these units of the present scenario of curriculum is concerned. Secondly, my dear students, as far as the units that have been divided into 4 units, one is Unit 1, which is mainly concentrating on the preliminary aspects of the definition, characteristics of the company, etc. And the second one is the other aspects relating to the company administration, company law, the directors, etc. etc. And the third one is with relating to the various aspects connected with the share certificates, shareholders, etc. etc. And fifth one is the last that unit is concerning with the winding up of the company, as the winding up precedes the dissolution. That we will take up in all these classes. By the way, first of all, what is meant by a company is, in the common parlance, as far as the company is concerned, it is nothing but, if you take into consideration, in the general connotation, it is a get together. As you know pretty well that we are in the classroom, we are a get together. So we are not concerned with the get together and general connotations. We being the students of law, we being the students of the company law, we are directly concerned with what the company law is telling about the company. the Indian Companies Act, the largely depending upon the English Companies Act 1948. And the company law in India is the generation from times of the Joint Stock Companies Act. How the company form of administration came into existence, that we should have to know first of all. Before going to take up the definition, before going to take up all the characteristics of the company and the definition, etc. As far as the evolution of the company is concerned, in the olden days, there existed the larger partnerships. Those larger partnerships have given a problem where the central management lies. That means the people who invested the money or money's worth, they are unable to find out where the central management lies. That is the main problem. That means with the larger partnerships. So then the company for evolution of the company came into existence. Why? Because of the difficulties, the bottlenecks that are being faced in the larger partnerships. As you know pretty well that in the partnership concern, all the liability of the partners is unlimited. That is, even the partners, they must have to indemnify, what we call the indemnification, you know the word which is appropriately be studied in our law of insurance. How indemnification is that? That is, indemnification is nothing but to indemnify the loss, to make good the loss. That means in the case of the partnership concern, if the partners, if there is any loss that is occurred in the partnership concern, they have to support those losses to be indemnified with the personal assets from the household property also. That is the main lacuna of the partnership concern. And in the partnership concern also, the members, the partners intercede. That means they may not be able to spend more and more amount of money as far as the partnership concerned, for which the company form of administration is very much needed. Because of the changing world, because of the modern era, where the expansion of the company is concerned. And now we will take up the company in general terms. General terms, as I already told you in the beginning, that company is nothing but a get together. But we are not concerned with the general term, as I already told you in the beginning. We are concerned with the company law only. What is meant by the company according to the company law terms, and also in the terms of the Justice Lindley, who has given, there are various others who have given various definitions for the company. That even Chief Justice Marshall of the United States of America also, he has wonderfully defined the company. But first of all, in the company legal term, company law terminology, we can define the company. That is, company is nothing but an association of persons united for a common object. That is, in the parlance of the company law terminology, it is an association of persons united for a common object, and that common object is to earn the profits. Is it sufficient in the company law administration, the profits so earned by the company, that they should be distributed from among the members of the company? So the members of the company, that means the profits, they have to be distributed, and the profits so distributed, so have to be distributed in proportion to the nominal value of the shares held by them. This is all about the introductory part of the definition of the company. That means association of persons united for a common object, and that common object is to earn the profits. The profits so earned by the company should be distributed from among the members of the company in proportion to the nominal value of the shares held by them. This is the definition as far as the legal terminology is concerned. Now we have to take into consideration the other definition. That is, as far as the definition part is concerned, the Chief Justice Marshall of the United States of America, what he defined as far as the company is, it is what he said, indivisible. In the words of Chief Justice Marshall of the United States of America, it is indivisible, intangible, and existing only in contemplation of law. Then what is meant by the in contemplation of law? In contemplation of law is nothing but in the eyes of law. That means the aspects related to the company in the eyes of law. That means it is in the eyes of law, it is an artificial person created. It is an artificial person created by law. It has no soul, it has no body, it has no mind, but it will work. So, in the eyes of law, it is an artificial person. What is meant by the artificial person? You can take it into consideration. It can sue and be sued in the courts of law. It can sue and be sued in the courts of law as far as the aspects related to the company is concerned. As far as company is concerned, the word company is synonymous with that of the corporation. So the word corporation has been derived from the corpus. That means a body, a group consisting, corpus. So that is analogous with that of the company. So when you take into consideration the aspects related to the characteristics of the company, there are various characteristics of the company. See, the characteristics of the company itself, they are automatically, the advantages of the company, the benefits of the company also, company form of the administration also. So, as far as the characteristics or the advantages of the company are concerned, it is not, as we know pretty well from the definition, we can infer various concepts from the definition part. From the definition part also, we can infer the characteristics of the company. As I already told you in the beginning, that is, it is an artificial person created by law. That means, see, the main advantage of the company form of administration is that of the company is having a different, separate, distinct entity from that of the members. The entity of the members is distinct from that of the entity of the company. That what happened in the celebrated case of the Salomon versus Salomon and Co. Salomon versus Salomon and Salomon versus Salomon and Co. So, as far as the company, in the Salomon company, what happened? There is one shoemaker, Salomon. He had a soul trading business. He wanted to convert to the top the one company by name Salomon and Company, and for which he named his wife, daughter, sons, all the family members as the members of the company, for which they have been given a consideration of the shares and debentures. At the time when the company is, has commenced the winding up proceedings, as already we will be discussing all these things in the fourth unit, that is dissolution of the company, and winding up of the company. Winding up of the company is nothing but it precedes the dissolution. When the winding up proceedings have been commenced, the assets and liabilities position has been taken into consideration. And the unsecured creditors, they want to claim on the pro rata at the first stage. And the court struck down the contention of the unsecured creditors. Why? Because after the registration of the company, after the incorporation of the company is a separate, distinct entity from that of the members, and the unsecured creditors, the futile exercise that has been done by the unsecured creditors became in vain. That means, because that is the advantage where the incorporation has been done. What is it? The incorporation is nothing but registration of the company. That is, upon the registration, there is a separate, distinct entity between the members and the company. That is the aspects which relating to as far as the Salomon company. That is an aspect which relating to the Salomon company. The Salomon case law is a foundation principle for which the entire company law instrument, the instrumentality of the company is largely depending upon. There is another important and celebrated case is also there. That is Lee versus Lee Safe Farming Private Limited. In the Lee versus Lee Safe Farming Private Limited also, Mr. Lee, who happens to be the pilot, who happens to be the director of the company, he died in the accident of the operations of the pesticides, pouring the pesticides. And at the same time, Mrs. Lee went to the court of law against the Lee Safe Farming Private Limited. The court said that Mrs. Lee has to be compensated. Why? Because even though Mr. Lee is a member pilot, member of the company, and also happens to be the pilot of the company, at the time when he died, he was an employee as a pilot of the company. And upon the registration, the company is a separate, distinct entity from that of the members, and they should be paid. And second one is perpetual succession. Perpetual succession means men may come and men may go, but the company remains the same. As you know pretty well, there is one the river Thames as an aspect. The men may come and men may go, I remain the same. The Thames River, it said. Like that, when all the shareholders where the meeting that is going on, they died, the company will remain the same. That is the perpetuality. And another one is transferability of the shares. There is the great advantage in the company form of administration is transferability of the shares and managerial personnel. Company form of administration is capable of deploying various managerial personnel, whereas the private partnership concern cannot go. Upon these characteristics of the company, I advise the students, if you pose any questions, you can make it for my email so that I will be able to explain in detail. Thank you very much.